Imagine this scenario. You're a dedicated federal employee, doing your job, serving the country, and then bam, a workplace injury throws everything off course.
Yeah, happens all the time.
So you do what you're supposed to do, right?
Yeah.
You file a workers' comp claim with OWCP, the Office of Workers' Compensation Programs.
You're right.
But then things change. That supportive environment you kind of expected, it just vanishes.
Yeah.
You might feel this subtle pressure maybe, or even face outright disciplinary action just for trying to heal and, get back to work.
It's a really challenging situation and unfortunately way too common for federal workers. Retaliation after filing an OWCP claim.
It is. It's a really tough spot.
Yeah.
And, sometimes agencies react negatively. Maybe they're worried about costs or productivity hits or who knows what.
Exactly. Understandable perhaps from their perspective, but devastating for the employee.
Totally unfair for the employee. So today, that's our mission for this deep dive. We're going to unpack this really complex world of federal workers' compensation retaliation.
We want to lay out your rights, the remedies available, give you a clear, practical roadmap, really, for navigating these awful situations.
We'll look at some real cases, legal principles, and importantly, the strategies you can use to protect your career and, frankly, your well-being.
And we're not just theorizing here. We're drawing from solid legal analysis for this deep dive. We've dug into final rulings from places like the Merit Systems Protection Board, the MSPB,
Right.
and the Equal Employment Opportunity Commission, the EEOC, plus relevant federal regulations.
So this is grounded in real experiences, actual legal battles people have fought.
Absolutely.
That's why this is so critical. By the end of our conversation today, you'll be armed with some really crucial knowledge. You'll understand not just what retaliation looks like, but maybe why it happens sometimes.
And most importantly, what you can actually do about it.
Exactly. This is your shortcut to getting well-informed on a vital issue for federal employees.
Okay.
Let's dive in.
So when we look at these patterns of retaliation against injured federal workers, they often follow a few kind of recognizable paths.
Okay.
One of the most severe, obviously, is unjustified termination, getting fired.
Right. Removal.
Yeah, removal. Think about a case involving the VA, the Department of Veterans Affairs. An employee, Robert Marcel, he was removed on misconduct charges right after taking medical leave for an injury.
Okay.
He was convinced, absolutely convinced, his removal was reprisal, retaliation for his OWCP claim and needing that medical leave.
And what was the outcome there? Did they buy his argument? Was the misconduct just a pretext?
Well, the MSPB, the Merit Systems Protection Board, they acknowledged the timing was suspicious. And yeah, maybe there were bad feelings, but ultimately they found the removal was legitimately based on a serious conduct issue. He'd apparently made a threat. So they decided it wasn't retaliation for the OWCP claim in that specific instance.
Yeah.
But the big takeaway, even though he didn't win, is that it highlights this common dynamic. Employees often point to that suspicious timing, discipline right after a claim.
Yeah, it makes sense.
As evidence. But the agency will always come back with, no, we had a legitimate non-retaliatory reason.
Right.
And the burden then falls on the employee to prove that the OWCP filing was the real underlying motive.
That's a really crucial point right there.
Yeah.
But it's not always something as drastic as getting fired, is it? Sometimes the pressure is, sneakier.
Oh, absolutely. It can manifest as forced retirement or resignation, sometimes called constructive discharge.
Constructive discharge, right.
And a really stark example of this kind of systemic pressure was the U.S. Postal Service's National Reassessment Program, the NRP.
Oh, I've heard about that, the NRP. What was that about exactly?
Yeah, the NRP, it was rolled out nationwide around 2009. Basically, the Postal Service started reassessing all employees who were on limited duty because of injuries. And very often, they'd suddenly claim there was just no work available within the employee's medical restrictions, even if they'd been doing modified duty for years.
Wow. So people who had accepted OWCP claims, doing modified work, suddenly told, no work for you.
Exactly. Many long-serving employees were effectively sent home without pay or felt intense pressure to just retire.
That sounds like a targeted program, not just isolated incidents.
It absolutely was. And there was a landmark class action lawsuit handled by the EEOC, the Equal Employment Opportunity Commission.
Okay.
And the EEOC found that the NRP did discriminate against injured employees. It violated the Rehabilitation Act.
How so?
Specifically, the ruling said the Postal Service failed to provide reasonable accommodations and, quote, engaged in disparate treatment against employees who were injured on duty.
Disparate treatment.
Yeah, including pushing them to retire.
Okay.
Basically, managers were targeting these OWCP claimants, stripping away their duties, creating impossible conditions.
So they felt they had no choice but to leave.
Precisely. Many felt forced to resign or retire. And the EEOC administrative judge ruled that this amounted to disability-based harassment and, yes, constructive removal.
That's a huge precedent then. It really shows the intense pressure to quit or retire after an injury, if it stems from discrimination or retaliation, can be deemed an unlawful constructive discharge.
Absolutely.
What about other patterns like demotions or being reassigned somewhere awful? Does that happen?
Oh, yes. Involuntary reassignment to less desirable duties or a straight-up demotion. That's another common retaliatory tactic. There was a case involving the Department of Labor. An employee, Ms. Van Kelsch, filed a traumatic injury claim. And while doing that, she also happened to disclose some alleged workplace misconduct she'd witnessed.
Okay, so two things happening there.
Right. And shortly after, boom, the agency reassigned her to a different position. She believed it was reprisal for, well, maybe both things.
And was it? Did they see the reassignment as retaliation?
Well, this case brought up a really critical legal distinction. The initial judge thought maybe some of her disclosures about the injury circumstances could potentially count as protected whistleblowing.
Okay.
But the full board ultimately dismissed her appeal for lack of jurisdiction. And here's the key point, because it's often misunderstood. Just filing an OWCP claim by itself generally does not count as protected activity under federal whistleblower laws.
Okay. That's important. It's seen differently.
Exactly. Her OWCP claim was viewed as an administrative benefits claim, getting compensation she was entitled to, not as a report of agency wrongdoing that triggers whistleblower protections.
So even if the pattern is there, getting sidelined after an injury claim, the legal path you choose to fight it really matters.
It matters hugely. Often you need to frame the reprisal differently, maybe as disability discrimination or an arbitrary personnel action, rather than just a whistleblower claim based solely on the OWCP filing.
Got it. Okay, what about creating a hostile work environment? Harassment. We hear about that a lot in employment law generally. Does that apply here too?
It absolutely does. Retaliation can definitely manifest as ongoing harassment, creating a truly toxic, hostile environment for the injured worker.
What might that look like?
Oh, it could be excessive scrutiny of your work, giving you really unpleasant assignments nobody wants, making threats, even management encouraging coworkers to ostracize you.
Wow.
In that big Postal Service class action we just talked about, the EEOC explicitly found that postal officials harassed injured workers and created a hostile work environment. That was part of the retaliation against OWCP claimant.
What kind of harassment?
Things like being publicly humiliated, maybe sent home in front of coworkers, being told point blank they weren't needed anymore. Just really demoralizing treatment.
That sounds awful.
It is. And think about another real-world scenario. An agency ordered an injured law enforcement officer to turn in his weapon and undergo a psych exam. Yeah, based on apparently unfounded accusations right after he filed his compensation claim, he clearly felt, and probably rightly so, that these actions were meant to intimidate him, to retaliate.
But agencies rarely admit it. Right. They don't say, we're doing this because you filed that claim.
Almost never. So you have to look for the clues. You have to show that retaliation can be inferred from the circumstances.
Okay, so what kind of clues are we talking about? What should someone look for to build that inference?
Well, the timing is often key. Did the bad stuff start happening very soon after you filed the OWCP claim?
Right. Temporal proximity.
Exactly. Also, look for deviations from normal agency practice. Are they treating you differently than they normally would, or differently than other employees? Did supervisors make comments, express frustration or animosity about your injury or the claim? That's huge.
Any explicit comments are gold, I imagine.
Absolutely. Or just a pattern. Is there a pattern of treating injured employees differently, more harshly? For instance, say you have a stellar work record, always got great evaluations. Then, right after your injury and claim, you suddenly start getting unwarranted reprimands, maybe a low performance rating, and maybe you overheard supervisors complaining about the claim. Those facts together really help build a case for a retaliatory hostile climate.
Okay, that makes sense. What about messing with the benefits process itself? Can managers try to, delay paperwork or just refuse to sign forms?
Yes, unfortunately, that happens too. Some retaliation isn't about firing you, but about trying to sabotage your OWCP benefits or your medical recovery.
No.
Managers might drag their feet on filing the injury paperwork, refuse to sign necessary forms, maybe forget to forward crucial medical documents to OWCP, anything to frustrate your claim.
I've heard stories like that.
Yeah, we've seen cases where a supervisor flat out refused, initially, to sign an employee's CA2 injury claim form. In another case, an employee alleged their supervisor intentionally held up OWCP paperwork.
And is that enough? Is a delay automatically retaliation?
Well, it's important to note that a short delay, by itself, might not be found to be an EEO violation unless it's clearly part of a broader pattern of discrimination or harassment.
So it's about proving malicious intent or seeing it as part of a bigger picture, not just, bureaucracy being slow sometimes.
Precisely. There was another EEOC case. A VA nurse claimed management totally mishandled his OWCP claim, which led to his benefits getting cut off.
Oh, wow.
And at the same time, he argued they failed to accommodate his medical limitations. He believed the agency specifically failed to forward required medical documents to OWCP, and that's why his compensation stopped.
Did he win?
He didn't ultimately win that particular case, but it clearly shows the type of claim someone might bring, arguing that management's poor handling of the injury claim or the return to work process is itself retaliatory or discriminatory.
And what's really vital here is that federal regulations actually forbid agencies from obstructing FECA rights, the Federal Employees Compensation Act rights.
That's a critical point. They cannot make an employee waive their right to file a comp claim. They can't deliberately delay or deny claims improperly.
And they also have a duty to offer suitable work if it's available for employees who are partially recovered, right?
Yes, absolutely. Agencies have that responsibility. So if an agency blatantly interferes, like refusing to process a legit claim or pressuring an injured worker to come back before they're medically ready, that can definitely be used as evidence of reprisal or what's called prohibited personnel practice.
Okay.
The recurring theme really is that some agencies, or maybe specific managers, react negatively when employees assert their injury compensation rights. And documenting these patterns thoroughly is just crucial for any legal challenge you might bring.
Okay, so we know the patterns. How do you fight back?
Yeah.
Let's talk about the EEO complaint process first. When does that route make sense?
The EEO process is a key avenue, especially when the retaliation against an injured worker overlaps with discrimination. Most commonly, that's going to be disability bias or maybe reprisal for some prior EEO activity. It's important to understand, though, that not every single dispute about an OWCP claim is automatically an EEO matter. The EEOC doesn't generally enforce workers' comp laws directly.
Okay, so what makes it an EEO issue?
It becomes an EEO issue if the injured employee is treated badly because of a protected characteristic, like their disability, or because of a protected activity, like asking for a reasonable accommodation, or maybe filing an EEO complaint previously about something else.
Got it. Then EEO remedies can apply.
Exactly.
And there's that really tight deadline people need to know about, right? That's something that trips people up.
Oh, absolutely critical. By federal regulation, you must contact your agency's EEO counselor within 45 calendar days of the alleged retaliatory act.
45 days. That's it.
That's it. If you suspect disability discrimination or reprisal is why you were removed or maybe forced to retire after an injury, you have to act fast. Missing that 45-day window can completely bar your claim. You lose your chance.
Wow. Okay, so you make contact within 45 days. What happens then?
Typically, there's informal counseling first to see if it can be resolved. If that doesn't work, you can file a formal EEO complaint. Usually, you have 15 days to file that after you receive the notice of your right to file.
And what goes in that formal complaint?
You need to clearly state your claims and the basis. So you'd specify discrimination based on disability and or reprisal.
Can you give an example?
Sure. You might write something like, I am alleging discrimination based on disability and reprisal. After I filed my workers' compensation claim on June 1st, I was removed from my position on July 15th. I believe management removed me because of my underlying injury, which is a disability, and in retaliation for exercising my rights related to that injury.
Okay, so you're explicitly linking the adverse action to the protected basis.
Exactly. That's how you frame an OWCP-related issue as a proper EEO complaint.
So once that formal complaint is filed, the agency investigates, and then you get a choice about a hearing, right?
Yeah.
Yes, that's generally the process. The agency investigates, compiles a report, then you usually have a choice. request a hearing before an EEOC administrative judge, or ask for an immediate final agency decision based on the investigative file.
Is a hearing usually better?
Often, yes, especially in retaliation cases. A hearing is really useful because it helps resolve factual disputes about the agency's true motives. Why did they really take that action?
Right.
During the hearing, you can present your evidence. Show that the agency's stated reasons were just a pretext, a cover-up for retaliation or disability bias.
What kind of evidence?
Things we mentioned before, the timing, how non-injured employees were treated differently, any hostile remarks from supervisors, deviations from normal procedures.
Right.
The agency will then present its side, articulating what they claim is the legitimate, non-discriminatory reason.
And then?
Then the burden shifts back to you, the employee, to prove that their stated reason is actually false or wasn't the real reason. Basically to show it was a pretext.
What happens after the hearing, or if you skip the hearing and just get that final agency decision?
Well, if you're not satisfied with the outcome, either the judge's decision after a hearing or the final agency decision, you can appeal to the EEOC's Office of Federal Operations, OFO.
And do people win these appeals?
Outcomes vary hugely. Depends entirely on the specific evidence. Remember that VA nurse case we mentioned?
Yeah, the one whose benefits got cut off.
Right. In his EEO case, the EEOC ultimately found no discrimination. They decided the agency had offered him a suitable light-duty job, which he declined. So his claim failed.
Okay.
But in stark contrast, you have that massive Postal Service NRP class action. There, the EEOC found systematic discrimination. The entire class of injured employees was found to be entitled to relief.
Wow, big difference.
Huge difference. It really shows that claims can fail if you can't clearly prove that link to discrimination or reprisal. But they can also succeed dramatically, especially if there's evidence of widespread discriminatory practices or direct statements showing bias.
And something you touched on earlier, which seems really crucial here and maybe people overlook, just asking for a reasonable accommodation, like light duty after an injury, that request itself is protected EEO activity, right?
That is an extremely important point, yes. The Rehabilitation Act legally requires federal agencies to provide reasonable accommodations to qualified employees with disabilities unless it causes undue hardship.
So if you get injured, file OWCP and then ask for light duty.
Any retaliation you face for making that request is explicitly unlawful reprisal under EEO law.
Okay.
So if a supervisor punishes you, mocks you, gives you a hard time specifically because you asked for light duty related to your compensable injury, you absolutely could pursue an EEO reprisal claim on that basis alone.
Even separate from the OWCP claim itself.
Exactly. These issues often overlap. An injury leads to disability, leads to an OWCP claim, leads to a request for accommodation. The EEO process is designed to look at all those connected factors, and retaliation is broadly prohibited if it would likely deter a reasonable person from engaging in any protected EEO activity, like asking for accommodation.
So the agency's own EEO office seems like it plays a pretty crucial role in these situations then.
Absolutely. The EEO counselors and specialists, they're supposed to be your first line of contact. They inform you of your rights, the process, the deadlines, and try to facilitate resolution early on if possible.
And if harassment starts after an OWCP claim?
The EEO office can investigate if you allege it's connected to your disability, which is a protected status, or retaliation for prior EEO activity, like that accommodation request.
All right.
Now, like we said, FECA itself, the workers' comp law, doesn't directly list reprisal for filing a claim as a protected EEO basis in the same way as race or disability.
Yeah.
But if that reprisal is tied to your disability status, or an EEO complaint you filed, or a request for accommodation, then the EEO office absolutely can and should take it on.
Makes sense.
And many agencies even have their own internal policies that explicitly forbid retaliation in workers' comp situations, reminding managers that FECA guidance itself prohibits discrimination in administering comp and return-to-work programs on bases like disability or reprisal.
Okay, so let's say you go through the EEO process and you win. Your claim of retaliation or disability discrimination is proven. What kind of remedies are available? What can you actually get?
The remedies can be pretty comprehensive, designed to make you whole.
Like what?
Well, they can include things like reinstatement to your job if you were fired, back pay for lost earnings during that time, restoration of any leave balances you used or lost,
Okay.
cancellation of any unwarranted personnel actions like a bad performance review or a demotion, compensatory damages for emotional distress, pain, and suffering caused by the discrimination or retaliation.
Emotional distress damages too.
Yes, potentially. And even attorney's fees if you used an attorney.
Now, what about the OWCP benefits? If you're getting wage loss from OWCP, can you also get back pay?
That's a good question. You generally can't get double recovery for the same period of lost wages. So any OWCP wage loss compensation you received would typically offset or reduce the amount of back pay you'd get through the EEO case for that same time period.
Okay, so no double dipping on wages.
Right. But importantly, FECA does not prevent you from pursuing these separate discrimination claims. You can win an EEO case based on disability discrimination or reprisal related to your injury and still keep your ongoing OWCP medical benefits, for example. The remedies are just adjusted to avoid that double payment for lost wages.
Got it. So through EEO channels, the main goal is to make you whole for the discrimination or retaliation you suffered.
Exactly. And the agency can be ordered to stop its illegal practices, provide training, post notices, things like that.
This really sounds like the EEO process is a vital tool, especially since, as you said, many of these OWCP-related retaliation cases really boil down to disability discrimination claims at their core.
It often is. It's a very common and important avenue.
But what if there's no clear EEO angle? Or maybe you want to challenge the adverse action itself more directly. What about appeals to the MSPB, the Merit Systems Protection Board?
Right. So the MSPB is another critical venue. It primarily handles appeals of major adverse actions.
Like what kind of actions?
Things like removals getting fired, suspensions that last longer than 14 days, demotions either in grade or pay, or reductions in force, RIFs, and also, importantly, enforced retirements or resignations, those constructive discharge situations we talked about.
Yep.
The MSPB also hears cases involving specific prohibited personnel practices, PPPs, and whistleblower retaliation, but under very specific conditions we need to unpack.
So if you're fired right after filing an OWCP claim, can you just appeal directly to the MSPB?
Generally, yes. If you face one of those appealable adverse actions removal, suspension over 14 days, involuntary demotion, or you argue you were forced to retire or resign, you usually have the right to appeal that action to the MSPB within 30 days.
30 days for MSPB, 45 days to contact EEO. Got it.
Exactly. Keep those timelines straight. So when you file that MSPB appeal, you argue the action itself was improper, maybe the agency didn't follow procedures, or the penalty was too harsh.
Okay.
But you can also raise what are called affirmative defenses. You can argue, hey, the real reason they did this was illegal retaliation.
So you bring the retaliation claim into the MSPB appeal.
Yes, you can argue it was retaliation for whistleblowing, if that applies, or for other protected activity, or, very commonly, you argue it was discrimination, which makes it what we call a mixed case.
Okay, a mixed case. But let's circle back to that really crucial point from the Von Couch case we discussed earlier. You said just filing the OWCP claim itself is generally not considered protected whistleblowing for MSPB purposes, right?
That's absolutely correct, and it's a point the board has hammered home repeatedly. They've consistently held that filing an OWCP claim does not meet the legal definition of the exercise of any appeal, complaint, or grievance right under the specific statute governing whistleblower appeals.
So it's not seen as blowing the whistle on the agency.
No. The Marcel case we started with explicitly reaffirmed this. An OWCP claim is seen as seeking an administrative benefit, not as initiating legal action against the employer for violating a law, rule, or regulation in a way that triggers whistleblower protection.
So what does that mean practically?
It means if you file an MSPB appeal claiming retaliation only because you filed an OWCP claim and nothing else, that specific retaliation claim will likely be dismissed by the MSPB for lack of jurisdiction under whistleblower laws.
Okay, that's a potential dead end if that's your only argument.
Yeah.
So if direct whistleblower retaliation for the OWCP claim itself isn't usually covered, what other angles are there at MSPB? What about other prohibited personnel practices?
Right. Beyond whistleblowing, there's another category of PPPs. One relevant type generally forbids agencies from discriminating against an employee based on conduct that does not adversely affect their job performance or the performance of others.
Okay, discrimination based on conduct that doesn't affect work. How does that apply?
Well, some employees have tried to argue that filing for their rightful injury compensation under FECA falls into this category of lawful conduct that doesn't impact job performance.
Interesting argument.
Yeah. In Marcel's case, the board actually discussed this possibility. They acknowledged that if an agency had animus, bad feelings towards an employee specifically for filing an OWCP claim, maybe it could be viewed as discrimination based on lawful conduct unrelated to work performance.
But
But proving the specific type of PTP violation is really challenging. You'd need clear evidence that management's adverse action was driven entirely by personal bias against you for filing the claim, or for reasons totally unrelated to your job performance. It's a high bar.
Sounds like a tough sell. What about those mixed cases you mentioned? That sounds potentially more straightforward.
Mixed cases are indeed a very common and often more successful way to bring these issues before the MSPB. A mixed case is simply an appeal of an otherwise appealable action, like a removal, where you also allege that the action was based on discrimination,
Discrimination
like race, sex, national origin, religion, age, disability, or reprisal for prior EEO activity.
Got it.
So in this context, if you were removed after an injury, you could file an MSPB appeal challenging the removal itself and claim the removal was actually unlawful disability discrimination or maybe retaliation for requesting accommodation, which is prior EEO activity.
Okay, so you combine the challenge to the removal with the discrimination claim.
Exactly. The MSPB administrative judge then has the authority to decide both issues in the same proceeding. Was the removal action proper on its face? And was it motivated by illegal discrimination or reprisal?
So MSPB can handle the discrimination part too. I thought that was EEO's turf.
They both can in these specific circumstances. You have a choice. You could pursue the discrimination claim through the EEO process first, or you can bring it directly to MSPB as part of your appeal of the adverse action. The key is the MSPB provides a single forum where you can argue that the adverse action was discriminatory or retaliatory.
What's the big advantage of taking that mixed case route at MSPB instead of just going through the agency EEO process?
Well, a primary advantage is that everything gets handled in one proceeding, potentially faster. And crucially, the MSPB has the power to actually reverse the removal or other adverse action. They can also order immediate interim relief, like putting you back on the payroll while the case proceeds, which the EEOC generally cannot do during its initial complaint investigation stage.
Okay, so MSPB can potentially offer quicker, more direct relief on the job action itself.
Yes. So a smart strategy for someone who's been removed after filing an OWCP claim is often to file that timely appeal with the MSPB, challenge the merits of the removal, and allege the removal was a pretext for disability discrimination or EEO reprisal.
And then the MSPB judge decides everything together.
Right. If the judge finds the agency proved its charges for the removal, but also finds the removal was motivated by illegal discrimination or reprisal, they will overturn the removal and order appropriate remedies, just like in an EEO case, back pay, reinstatement, etc.
Okay, that makes a lot of sense. Now, beyond discrimination or retaliation, are there any other specific rights related to injuries that the MSPB handles? You mentioned restoration rights.
Yes, absolutely. This is a separate and very important legal avenue at MSPB, specifically designed for employees who lose their positions because of a compensable injury.
How does that work?
Under federal law and OPM regulations, agencies have very specific, clear obligations to restore employees to employment who either partially or fully recover from a work-related injury for which they received OWCP benefits.
Okay, a duty to restore.
Yes. And if an agency fails to meet these legal obligations, you can appeal that failure directly to the MSPB based solely on your restoration rights.
What kind of obligations are we talking about?
For example, regulations require agencies to make every effort to restore an individual who has partially recovered from their injury and is able to return to work in some capacity, perhaps with limitations, limited duty.
So if you're partially recovered and can do some work, they have to try.
They have to make every effort. If they deny you any employment when you believe, and your doctor believes, you could perform some work, maybe with accommodations, you can appeal to MSPB, claiming a violation of your partial restoration rights.
What if you fully recover?
There are even stronger rights if you fully recover. If you fully recover within 1 year from the date you first became eligible for OWCP compensation,
Within 1 year?
you are legally entitled to be restored immediately and unconditionally to your former position or a fully equivalent one.
Entitled. That sounds strong.
It is. An agency's failure to put you back in your job, or an equivalent in that scenario, is a clear violation directly appealable to MSPB.
What if recovery takes longer than a year?
If you fully recover after 1 year, the entitlement isn't quite as absolute. You get priority consideration for restoration to your former position or an equivalent, meaning they have to put you at the top of the list, but they aren't required to bump someone else, for example. And if you're partially recovered, again, they have that every effort obligation to find suitable placement, maybe a light-duty assignment.
There was a Postal Service case you mentioned.
Yes, a case involving the Postal Service back in 1999 really highlighted these different restoration rights: fully recovered within a year, fully recovered after a year, partially recovered. These appeals often hinge on the medical evidence and the official OWCP decisions about your recovery status.
So it sounds like the MSPB acts as a check to make sure agencies don't just use an injury as an easy excuse to get rid of someone unfairly, even if recovery happens.
Precisely. If an agency acts arbitrarily or capriciously, for instance, by just declaring, oh, no job exists for a partially disabled employee, when suitable tasks clearly are available and could be assigned, the MSPB can step in. They can order the agency to properly restore the employee and provide back pay for the period they were improperly denied restoration.
And importantly, for these restoration appeals, you don't necessarily have to prove retaliation or discrimination, right?
That's a key distinction. These restoration appeals focus solely on whether the agency complied with the specific civil service regulations governing the reemployment of injured employees. You don't have to prove the manager had bad motives or retaliatory intent. You just have to show the agency failed to follow the law regarding your right to be restored to federal employment after your injury.
Okay, that seems like a really important, distinct path for people recovering from injuries.
It absolutely is.
So we've covered a lot of ground here: what retaliation can look like, the EEO process, MSPB appeals, including mixed cases, and these restoration rights. This has been a really detailed deep dive.
It's a complex area, definitely.
So pulling it all together, what does this all mean for someone who might be navigating these difficult waters right now? What's the biggest takeaway for them?
Well, we've journeyed through this pretty intricate landscape of federal workers' compensation retaliation. I think the clearest point is that while just filing the OWCP claim itself might not always fit neatly into, say, whistleblower protection,
Right.
retaliation that's intertwined with disability discrimination or happens because an agency fails to accommodate you is unequivocally unlawful.
That connection is key.
It really is. And you've learned, hopefully, about the critical role of documenting everything. Those strict timelines you absolutely cannot miss for filing complaints.
Yeah, 45 days for EEO contact, 30
Yeah.
for MSPB appeal.
Exactly. And the power of clearly articulating that connection, the link between your protected status, like disability, or your protected activity, like requesting accommodation, and the adverse actions the agency took against you.
And it's just so important to hammer home that agencies have a positive duty here. They're supposed to facilitate your return to work when possible. Their job isn't to marginalize you or push you out just because you got injured on the job.
That's absolutely right. And the legal frameworks we've discussed today, whether it's through the EEO process or MSPB appeals, they are specifically designed to hold agencies accountable to that duty.
And this isn't just about one person's case, is it? It's bigger than that.
It really is. This is about upholding the fundamental principles of the federal merit system. That system is supposed to protect employees from arbitrary actions, from personal favoritism, from coercion based on factors that have nothing to do with merit.
And retaliation for exercising your legal right to injury compensation seems like a prime example of an arbitrary non-merit factor.
Exactly. So by understanding these rights and knowing how to use these avenues for redress, EEO, MSPB, you can help ensure those fundamental principles are actually upheld, not just for yourself, but really for all federal employees.
So, wrapping up, in the federal workplace, absolutely no one should ever be forced to choose between their health and their career. That just shouldn't be the choice.
Agreed.
So a final thought for everyone listening. Knowing this information now, what steps can you take today to safeguard your own rights or maybe the rights of a colleague you know who might be going through this? Think about the power that comes with just knowing your rights and knowing these mechanisms exist to enforce